Hello, everybody, and welcome back. In this lecture, we're going to be closing out the class actually by talking about our very last topic. And this one's sort of unique. We're going to be looking at how social psychology plays a role in our legal system. But before we do that, I want to provide a bit of context and give you an explanation as to how and why we're going to tackle this material. So, if you've noticed as we progress throughout this class, what we've aimed to do up until this point is try to cover the different general branches of interest that social psychologists discuss. We've looked at things like emotions and social cognition, aggression and prosocial behavior, attraction, a whole slew of different things that can find their way into other topics that aren't necessarily social psychology research related. There's essentially lots of applications to a lot of the different things that we've been looking at. But what we haven't necessarily done a lot in this class is look at those places where these things apply. If you look in the textbook, what you'll see is at the end of this book, and this is typically the case for pretty much all of our social psychology textbooks, many authors focus their attention in the last few chapters on places where we can see social psychology concepts that we've been covering abundantly applying in those specific situations. This particular topic of social psychology in our legal system is one of those places where there's an abundant amount of overlap from the material that we have discussed with what people studying the law and trying to consider social psychology factors have kind of found links in. And this is what is going to be the main focus of this class. We're not necessarily going to introduce as many terms and concepts as we have in previous classes, but being able to understand how social psychologists can use their research and their ideas to apply them in the legal system is something that we're going to explore in this class. And what I want you to understand is that, again, this is just one of the many different areas, specific events where social psychology topics that span a wide range of different things that social psychologists look at can abundantly apply to those situations. So even though we're just going to focus on social psychology and the law, if you want more information on this, I encourage you to go into the readings, read about other situations, and then also find other specific topics within, say, business and economics and education and other places where you'll see a lot of our terms and concepts we've covered in this class popping up continuously and having real tangible explanations for some of the things that these individuals study. So how does it work in our legal system then? Where do we see social psychology concepts coming into play? Well, the short answer to that is everywhere. There's every step along the way within our legal system. We have components to social psychology and cognitive psychology and other branches of psychology that do influence these different elements to our legal system. Now, since we don't have an infinite amount of time to cover these things, we're going to narrow our focus down to three major areas where we can see some of the different social influences that we've discussed having an impact on this kind of component or these components in total in the legal system. We're going to start our focus on the topic of eyewitness testimony and also something oftentimes paired with it, police interviews, either interviews of eyewitnesses or potentially, as your book talks about in a lot, interviews with potential individuals who could have committed specific types of crimes. We're then, after we look at that specific topic, going to talk about observers and how they can be impacted either in the trial or just when trying to understand what happened in a case. And after we talk about these impartial observers, we're going to really break down the different components happening in our court systems and how they, even though we tend to think of them as a relatively sterile thing that's devoid of social factors, actually have numerous social components within them that relate to topics that we've discussed in the past. As I mentioned, we're going to focus our attention first an eyewitness testimony and police interviews, and how there's, well, not hundreds, but many different types of elements that we've been discussing in class that apply to these situations. Let's look just first at the moment a crime occurs. Let's say you're walking down the street and suddenly a loud bang happens and a bunch of people go running off, and there's somebody that's lying on the ground saying they've been shot or they've been hurt, and you're asked to explain what it was that happened, what it was you saw, and if you were able to identify who committed this crime. Well, there's a lot of things, unfortunately, in that random situation that aren't necessarily going for you. One of the things that's oftentimes a problem with crimes, and this is something that's not necessarily represented very well in television shows and movies, is when a crime occurs, these things, at least in our interpretation as eyewitnesses, happen very abruptly. Everything's fine, and then all of a sudden, bam, something happens. It doesn't have to be somebody shooting another individual. It can be something as simple as somebody jaywalking, or somebody stealing another person's purse, or somebody doing something verbally to another individual. We don't necessarily expect these things to happen until they are actually happening. And then it's our job to sort of scan that environment very quickly to better deduce who did these things and what led up to those specific events. And unfortunately, because of the way our bodies are activated, we tend to not be very good at making these snap judgments. Numerous studies have shown that we're in high states of arousal, where we're highly activated through that sympathetic nervous system that we've mentioned previously. And unfortunately, our focus tends to go on the things that are of critical importance, like where the shout came from, if there's anything else that's going on in that environment that we need to attend to immediately, and how we can protect ourselves in this kind of highly now perceived as dangerous situation. We don't necessarily think about the things that might be important later. We just focus our attention on the things that are important now. And by having this sort of hyperfixation on things, we don't often see a lot of critical things. Another thing that's a big problem is that usually these things do oftentimes happen in crowds, and they happen in places where maybe it's darker out, or we just can't see things because we're not right next to them. All of these things coalesce together to, unfortunately, prevent us from having much of a chance of really interpreting things correctly, even if we know what it is we want to interpret. And unfortunately, as I mentioned, we can sometimes, because of how drawn in we are to things, be focusing so much on the wrong thing that the critical elements are gone. One researcher that really highlighted how impactful this could be, well, a pair of researchers that highlighted how impactful this could be, were researchers named Simon and Chabris, who back in 1999 ran this very interesting study highlighting what we call selective attention, our inability to catch key elements of a scene as a result of our kind of hyperfixation on one thing. In this study, individuals were asked to watch a video, like the one you see pictured on the right, of individuals playing with two separate basketballs. There was a white team and a black team. And most participants in this study were told to focus their attention on the white team and to count how many people touched on the white team the basketball that they were using in this short clip. They were instructed to not try to count the number of times the people on the black team touched the ball, but just the number of times the white team touched the ball. I'm hoping we can replicate this here in class, but if this video doesn't work when I hit play, I did provide the YouTube link to it, so you could potentially watch it on your own, even though I apologize in advance for needing to copy down that exhausting URL onto a slide, or onto a website. But here we go. I'm going to try to play this and see if you can do this. Count the number of times the white individuals, the white shirted individuals, touched the basketball that they're using. Again, if you can't see what's going on here, go to the website. All right, now some of you probably saw that the team passed the ball 15 times, but most of you maybe missed that wonderful thing that happened in the middle. I don't want to give it away if you actually aren't watching the video, but if you are, and you saw the language, I'm guessing you saw what was also included in that video. I'm encouraging you, if you haven't seen it, to go there to the website link that I provided you on this page and fully appreciate how easy it is to miss certain things as a result of our fixation on stuff. And I want to reiterate to you, in this environment, you aren't necessarily on edge while you're watching this video. In fact, you're probably suspicious that there is something going on, and you're probably going to be more receptive to picking up on something than most people typically are. If you do change the scenario a little bit, researchers have shown that it's even more challenging to pick up on that hidden thing within the video. If you, say, incentivize it to where you're paying people to get a certain number correct, or telling them something bad will happen if they don't count the correct number, all of a sudden that hidden thing becomes almost impossible to see. And again, it highlights how many people going into reporting what they saw in a crime are probably coming in with a very imperfect description of what they've encountered. Another issue that sometimes occurs when individuals are trying to identify what it was they saw in an event relates to who they're looking at during these crimes that they're observing. Numerous social psychologists have shown that when people are asked to identify specific faces in, say, a lineup, they're challenged to do this unless they had a very clear look at the person they're encountering. Our previous slide just suggested that we probably don't have a super clear image of who we're looking at. And some researchers, after our initial discoveries of how challenging it is to identify people because of the surrounding circumstances, asked then if there were any additional things that could throw things off. One of the things that they discovered was that the race or the specific group that a person was a part of could, but not guaranteed, but could play a role in a person's ability to successfully identify somebody. The could component to it related primarily to whether or not the person identifying another individual was a member of the same group, either the same race or same age group or same kind of collective group that they were observing. As there's more and more overlap between individuals and the person they're being asked to identify, their ability to distinguish between things gets, well, fairly good. And this is true for almost everybody that's been studied and examined in these specific scenarios. It's also important to note that it's not quite about being able to identify just us, even though there is lots of research that suggests that there are these in-group, out-group biases that we've talked about before, where we assume out-group homogeneity and that everybody who's a member of an out-group possesses pretty much the same characteristics. As one study in 2005 also suggested that it's more to do with exposure than just assuming that everybody's part of the same group. There was a researcher named Sangrigoli, and a number of other individuals that participated in this study that showed that when people were raised in groups that weren't necessarily the same as the kind of group that they were a member of, so adopted children or people that grew up in communities that were very different from the, say, race or age group that they were from, they were able to show was that these people were actually more astute at differentiating between members of the group that they were constantly exposed to than members of the group that they technically were a member of. And this threw some added complexity into the story. Right? It's not just about us versus them when we're trying to identify people. It's about who we're exposed to and who we've learned to kind of come up with things that help us differentiate from one person to another. All of these wrinkles make, again, the eyewitness components to many of the things that we encounter in our legal system very complex and hard to dissect. Once those interviews start, there's also another really big component at play that we want to consider. And that's how these individuals are coming up with a description of what they encountered. Numerous police officers over the years and even researchers on the topic have assumed that when somebody as an eyewitness is asked to describe things, they're going to describe things the way they encountered them, regardless of how they're asked to describe these things, regardless of whether or not they've been given certain questions or been asked to look at things in a specific order. Now, there was one particular researcher a number of decades ago named Elizabeth Loftus who questioned whether or not that kind of universal type of reporting was going to occur independent of the types of questions that people were being asked. Essentially, Loftus suggested that maybe leading questions, maybe framing things in specific ways, could potentially lead to dramatically different interpretations of events that people encounter. One of our first studies that looked at this effect had individuals watch a slideshow of a car traveling down a street and taking a right turn, and as it took this right turn, get into an accident. Now, some of the people in this study saw the car taking a turn with a yield sign. Other individuals saw the car taking a turn with a stop sign. And they were just asked merely whether or not they saw the stop sign or yield sign on this. What most of her studies showed was that people tended to report seeing whatever it was that they were either asked if it was there, or it was kind of subtly implied was there in the questioning that was asked. This was just one of many studies that Loftus did, though. Another thing that she did was she had individuals watch accidents and ask them how fast the cars were going when they hit each other, or when they bumped into each other, or when they smashed into each other. And what she was able to show was that just the phrasing of the questions dramatically impacted people's estimates of speeds. She also did studies to show that the younger the people were when they were being asked these things, the more likely they were to have their memories of specific events impacted by the type of questioning and the wording that was used when asking for some type of reproduction of the events. And when she tried to explain why this was the case, many researchers argued that maybe she was suggesting that people were gullible. Her insistence was it was more about us not really understanding our memories very well, about our memories being imperfect stories. One of the things that's often cited as a kind of an explanation for this is this idea of something called source monitoring, where we really struggle to remember what it was that led us to believe something happened in a specific event. Was it somebody telling us something happened, or was it our actual memory of how something occurred? Well, let's say, for an example, you went to a party and there was a lot of noise at the party and everybody you thought was having a pretty good time and everybody was socializing, and then you find out from one of your friends the next day that they got into a horrific fight, and a lot of the noise was actually them fighting with another person at the party for an extended period of time, maybe shouting at each other and screaming about things. You might, when you hear this, sort of misremember some of the events. You might suddenly think of the party as a little bit more hostile and tweak your memory on what it was you saw and heard. And if you try to remember why you suddenly start to remember things in this way, you might not be able to differentiate at that point between what it was you truly remember and now what you think you remember based on the things that you were told. This is obviously not necessarily a huge deal in the example, but obviously in our legal system it matters a lot. If specific questions that police officers or interrogation specialists ask can tweak dramatically a person's report of something, we need to be mindful of this. And in fact, this was what Loftus championed when she discovered these effects. She was a very big advocate for changing the interview process, both for people who were observing crimes that had been committed and those that had potentially committed a specific crime. Her insistence was that the way people were asked questions, the types of questions that people were asked, could lead to dramatically different recreations of events, ones that oftentimes conformed to what the expectations of the interviewer was. And she insisted if we wanted to be this, again, sterile thing that many people in our legal system argue there is, we need to avoid these types of leading questions in interviews. And it did lead to some changes in lots of places. Many police officers, when interviewing people, are asked not to request leading information anymore, but instead asked simply to ask the participants of these interviews to just tell the police officer or the interviewer what it was they experienced, what it was they saw, without any extra questions being embedded while they're providing their descriptions. It might not get to a perfect view of things. It might not eventually get to everything that these interviewers are trying to assess. But in Loftus's mind, and in the mind of many people who have looked at her data, it's probably a more accurate interpretation of the things, even if it's not quite as robust. And this leads us to another big issue when we come to false memories and false perceptions of things. One would think that if somebody's memory was altered and they're not feeling super confident in whether or not they remembered things correctly, that we could gauge this in our assessment of somebody's report. Because remember, it's not the eyewitness that's going to determine if somebody committed a crime or not. It's usually a jury, it's usually a judge, it's usually a number of individuals that are assessing the merit of the eyewitness's reports. Someone would think that if an eyewitness doesn't feel great about what it was they saw and they're questioning where their memory actually lies, that any impartial person hearing them report things would be less inclined to believe what it was they're reporting. But there were numerous studies in the 1980s and 90s that suggested that the feelings of accuracy of eyewitnesses don't often align very well with the trust in eyewitnesses that many jurors and other people in the legal system display when these people report what it is they saw. In essence, are usually way more confident in the reporting accuracy of eyewitnesses than the eyewitnesses themselves. One study that really highlighted how powerful this effect could be was done by a number of researchers back in 1981, where they had participants come in and participate in what they sort of sold as a relatively benign, silly survey. What they didn't know when they arrived is that the true experiment had really starting the first second they walked in the room. For many participants, when they walked into the room, they'd see a specific person sitting in the front row out of a number of individuals, and this individual had one of two things on them. They either had a very low hat that was covering their face, a high hat that was simply just kind of resting on their head but allowed people to be able to see this person's face, or no hat at all. This person either sat there for 12 seconds or sat there for 20 seconds in the no hat condition, that is. And after this person sat there for this extended period of time and everybody is kind of getting themselves settled in, the person got up, went to the front of the room and grabbed, I believe if I recall correctly, a calculator of the research assistant that was supposedly running the study. After grabbing it, the person walked off never to return again, and the research assistant asked everybody in the study to try to identify who it was that had taken this calculator, and they were actually given a series of images to try to figure out of the images who the person was. Now, as these researchers predicted, people's confidence in whether or not they saw the right person was highly impacted by the condition they were in. When they didn't feel like they saw much and the person had the low hat and they were only there for a few seconds, their ratings of confidence as to whether or not they were sure that they were identifying the right person were really low. And in fact, these people weren't very accurately identifying the person. People, as they saw the person more with a high hat, tended to rate their confidence a little bit higher and were a little bit more accurate in their perceptions. And those that saw the person plain as day, that were almost, well, not always right, but right much higher percentage of the time, were not only more confident in what they saw, but they were actually more accurate in the reports of who it was they saw. But here's the catch. Not only did these researchers ask these individuals to report their confidence, but they recorded them. They had other individuals look at their reports, and they asked them to rate how confident they were in the eyewitnesses, how certain they were that the eyewitnesses identified these people correctly. And what we found, or what they found in this study, was that people tended to, especially in the poor observation situations, overestimate how accurate the eyewitnesses were, and give them essentially much more credit than they were giving themselves. And this has been seen as a consistent thing within our legal system for centuries. Eyewitnesses might not be 100% sure of who they saw, but the jurors, the judges, the ones involved in the legal case might be much more inclined to believe these eyewitnesses. And that can lead to very faulty conclusions about what was seen, what was said, and what happened in a specific event. And this, of course, is all operating on a situation where the person reporting something is being 100% honest and transparent. Unfortunately, we've learned over the years that there's many cases where individuals reporting what they saw aren't being 100% honest. There's also many cases when people are being interviewed for potentially having committed a crime, where they're not being very honest with what they did and why they were doing some of the things that they were doing. And this leads us to another really interesting question. Not only should we trust the accuracy of those involved, but I guess should we trust and believe the things that certain people are saying? And well, can we detect a lie if somebody is trying to lie within the legal system? And I'd like to, in the class, when we do this in an in-person class, play a pretty fun game. I ask participants to come up and have a script in front of them, well, not a script in front of them, but a question in front of them that they have to answer in front of the class. They're either asked to tell everybody about their first date or their first trip out of state. Usually this is a California class, so I say the first time you left California. I also instruct them that they're either going to have to lie or tell the truth on these things based on the other card they draw. Some people are told lie about your first date. Some are told lie about your first trip out of California or tell the truth about your first trip out of California. It essentially falls in two directions, whether or not people are going to lie or tell the truth on whichever story they're assigned. Then these participants come up in front of the class and tell these usually very elaborate stories, and everybody's asked to guess whether or not the person was lying or telling the truth, and how confident they were in their estimates of whether or not somebody was lying or telling the truth. Everybody runs through these things. We hear awkward stories. It's still kind of fun. Everybody's giggling. Everybody's usually very confident in what they come up with. And then we go through each of the 10 participants and find that people in this particular situation, in this particular activity, really, really suck at being able to judge whether or not somebody's telling a lie or the truth. And more importantly, Usually, when we're not very good at it, we're also simultaneously really bad at being kind of accurate in our confidence of how sure we are about whether or not somebody's lying or telling the truth. There's essentially almost no correlation when we do this between people's confidence and whether or not they're accurate in their perceptions of whether or not people are telling a lie or a truth. And this lack of correlation and lack of ability to detect things is something that has been a topic of conversation for social psychologists and people involved in the law. Their main conclusion through numerous studies that they've run is much like we often find in our class, that we're not necessarily very good at detecting lies at all. Instead, what we tend to see when it comes to people's ability to detect lies is it's more about the lie teller than the person who's trying to decipher it. I know many of you might be thinking that there's police officers and interviewers and interrogators that are specifically trained in this, and they must be significantly better at picking up on lies and truth. Well, to an extent, they are. They're usually better at asking questions that put people in compromising positions that make their lies a little bit more easy to detect. But, there are differences from person to person as to how good we can lie. And those that can lie well, unfortunately, there's not a lot of training. There's not a lot of things you can do to be able to catch these people in their lies. And this is something that, again, has been examined by social psychologists and people looking at the law to try to take these things into account. As again, in a sterile, perfect world, we have eyewitnesses that get to see everything, and they're being 100% transparent and honest, and we're taking them for their word at the level that they should be taken at based on their insistence of how accurate they probably are. Well, that's not often the case. There's lots of misperceptions, and unfortunately, there's lots of people, both eyewitnesses and people that are being interviewed for the potential of having committed a crime, that aren't telling the 100% truth. And juries, judges, these individuals are all trying their best to do something that's really, really hard, and that's be able to parse out those truths and lies and how accurate people's perceptions are when they are trying to tell the truth. So I'm hoping now at this point you understand there's already a lot of complexity going into all the information hidden within the trial, but we haven't even at this point covered all the different roles that people are playing in a trial beyond just the person that has potentially committed a crime. You also, in addition to having these jury members, 12 to be precise, you have these judges that are asked to sort of have an impact on the way that a court case unfolds and consider what's admissible and what's not admissible and who gets to do what and how this can kind of abide by some of the legal standards that are set forth by the state or government that's involved in these trials. You also, in most court cases, have somebody that's prosecuting the individual who's on trial, and you also have somebody that's defending that individual on trial. We tend to call these people lawyers, and sometimes lawyers exist in different forms depending upon the type of legal case we're looking at. But in essence, in almost every case, you're going to have these elements to it. I guess technically in some cases you maybe don't have jurors, even though that's the case for all criminal cases in the United States. It's not universal across countries. And in other kind of more civil cases, juries aren't there, but a judge and lawyers are typically going to be there in pretty much every situation. And you might ask if they're there, or there social psychology factors at play in their roles or their contributions to this specific situation. And as I'm guessing you've probably already concluded, indeed they are. How is the judge impacted by things in these cases? If a judge is just there to make sure that the proceedings are following according to some set plans or some kind of set rules that have theoretically been established for everybody, how could a judge sway a court case? How could a judge have any detrimental or advantageous impacts on something. What we have to understand is that judges, even if they are trying to be impartial, are not internally oftentimes impartial during court cases. Many judges report that they've come to conclusions on their own about the guilt or innocence of somebody or how to move on some specific topic, even if it's not necessarily their jobs in these cases to make those final decisions. They're human. They do make some type of judgment. And these judgments are often, well, not impartial. They're very partial. Many times, researchers have shown that when judges are the kind of overseeing cases for individuals that are not parts of their in-groups, again, this usually relates to things like race, but it could also relate to gender, and it could relate to, I don't know, weight, it could relate to age, lots of different things. When these people don't see the individuals on trial as kind of different, or I guess the same for them. They see them as part of what we again call outgroups. Their perceptions of these individuals can be shifted. Usually you apply more stereotypes to these outgroup members. Usually you do have an inclination to assume that any behaviors that they display are more about them than the situation. And all those elements of stereotyping that we talked about before with the negative perceptions and the kind of conflict-related ideas come into play. And it tends to mean that individuals who have judges from outgroups that are the same as theirs tend to be convicted more often and have judges that seem to display biases against them in many trials. And obviously, if we're looking at the flip side of the coin, we tend to see the reverse for judges that are overseeing court cases of individuals that are perceived as in-group members, people of the same age or race or whatever group that they align themselves with. And again, many of you might think, who cares? Yeah, judges maybe aren't impartial. Why does that matter? Well, numerous studies have shown that impartial judges can have a dramatic impact on the outcome of a court case. There were studies done way back in the 1960s that showed through these exhaustive data analyses studies, or I guess databases, that court cases were very highly determined by the biases that judges had in a case. Only about 25% of judges reported disagreeing with their jury in most court cases, in most criminal and civil cases where judges and juries were involved. And this is a number that many people believe has actually gotten even more extreme. Now, obviously, that might mean that both the judges and the juries are right in certain conditions, if there is technically a right and wrong in some case. But there's probably also a lot of room for doubt where judges and juries are coming to the wrong conclusions, but they're coming to the wrong conclusions together as a result of some of the biases that maybe the judges are carrying with them in these cases. Why might this happen? Why might this be so impactful? All we need to do is go back to the Solomon Asch studies where individuals did lots of different things. A judge treated somebody a specific way, and then the true participants got to act. And what they tended to do was, well, conform to the behaviors of others, both the judges and other people involved in the court proceeding. We also even apply Stanley Milgram's research in this, talking about how having that power, the kind of authoritarian command, could have a big impact on people's perceptions of something and people's willingness to believe one thing versus another. In total, what I want us to understand is that even the individuals that really have the sole job of being the impartial coordinators in these trials are often not impartial. It's possible to not be impartial. And even if there is no intent of showing the biases in these trials, data seems to suggest that these biases are leaking out and they're impacting court cases, at least to some extent. And it seems to be a logical thing to make or conclude and to expect if you look at all the other studies that we've examined in this class throughout the semester. Now, another very important group that we mentioned earlier in these trials are these individuals that we call lawyers. Now, in most court cases, especially criminal ones in the United States, you have two lawyers. You've got the prosecution, ones that are trying to find ways to convince jurors that the person accused of doing something was actually the person that did it. And then you've got these things that we call defense lawyers, people who are trying to show juries or a judge that the person being accused of something is innocent. And these individuals tend to, in their attempts to try to convince juries or judges of the innocence or guilt of somebody, weave these very intricate stories and talk about specific precedents and things that need to be considered in these cases. They're essentially storytellers. They're people that are operating under specific parameters, but they are storytellers to an extent. And if we talk about stories that we try to tell, we can go back to something that we covered months ago in our social cognition topics of stereotypes and scripts. If you remember back to these ideas of how we make sense of things in our world, we talked about how on many times when trying to understand different elements of our world, we create these things called schemas. General gist ideas of either the unfolding processes in something we call a script, or the elements of something that come together that make that thing complete, what we call a stereotype. Obviously, we talked about stereotypes in other forms as well, but this kind of pairing of things together is the essence of stereotypes. And this leads us to a really interesting question that was asked a number of decades ago. If we do have to weave these stories in court cases, or lawyers have to weave these stories in court cases, and these stories often surround some type of schema that they're trying to get people to think of, which type of schema should lawyers get people to come up with? Should they get a coherent story about the person that's on trial, trying to understand who they are, what their motives are, what would potentially be important to consider when understanding whether or not they had committed a specific crime? Or would it be more advantageous to use a schema of a script where we try to kind of lay out the scenario that occurred and try to get people to think about whether or not the person on trial really did do the things they're accused of doing? Which one would be more effective? How could jurors and judges process the information differently based on the stories that are being woven? Well, if we go back in history to cognitive psychology and its connection to social psychology, numerous studies have shown that our memories of these things, these stereotypes and these scripts, is not necessarily equal. When we're learning new information about stuff, we tend to, when learning that information, sort of bring the things that were being presented and try to find a way to kind of create a unifying story within it. Something that makes sense, either a progressive step-by-step thing that happens or a progressive thing that aligns with what we already believe and understand. And one of the, I guess not studies, but one of the mediums that we used historically to highlight how impactful this could be was this very convoluted story called The War of the Ghosts. Now, if we were in class, I would again stop everybody and read this long story in front of the class, but also to one particular individual that I would ask to retell the story to another person that I intentionally would take out of the room before reading the story of the War of the Ghosts. That person who listened to the story would try to recreate the story to this one individual, And then this person would try to recreate the story to the class. And what we find, every single semester I do this, is that the reiterated story, the third time around, is very butchered in comparison to what the class heard as a whole. One might think that it doesn't make much sense if it's only just two people conveying stories. But you have to understand that this story is very complex. It bends a bunch of different directions. It has lots of superfluous things hidden in it. And it doesn't fit the typical story that we think of. There's no logical progression of things like we see in most scripts. There's no ways that we can clump a lot of the characters within it in specific types of stereotypes. So what comes out is this garbled mess of forced information together, so we can sort of, by the third iteration, find a way to align this garbled mess with something that feels more story-like, something that has scripts and stereotypes embedded within them. And this, many people believe, is happening in court cases. There's this garbled mess that is a component, or I guess a collection of components in a trial. And what lawyers need to do is find a way to make this garbled mess into something palatable, something memorable for jurors when they're deliberating and thinking about the innocence or guilt of an individual. This, of course, leads to the question of, well, which garbled mess should you, I guess, eventually evolve into? Do you want one that gives you that theme of the person, or do you want one that gives you a theme of the event? Well, numerous studies have shown, but my favorite one is the one that you see listed here, this one by Pennington and Hastie, that if you want to be a good lawyer, your best bet is to focus on the story itself, not the individual. And this is true not only for, say, the defense, but it's also true for the prosecution. When lawyers present cases on a chronological order, in the prosecution, you see almost a 20% bump, 20 to 30% bump in conviction rates versus witness order. And in defenses, you see almost a 20-30% drop in conviction rates when you present things in story order versus witness order. In essence, presenting things in a palatable, package is ideal as a lawyer, period. But there are differences from package to package as to how things are presented. And all of these things are things that lawyers and juries and judges are sort of aware of and are considered important in the legal system. Unfortunately, though, when we look at them, we recognize their influence, but we don't necessarily, even today, control for them very well. It means if we're looking at this in the grand scheme of things, having a lawyer attuned to this, having a lawyer that can tell a good story, is indeed really, really important in cases. And this then brings us to the last group that's a component to these cases in the first place, the jury itself. We have probably already highlighted how juries have all of these different influences pushing them in different directions. You've got good lawyers and bad lawyers. You've got judges that impact people with their biases and the way they're treating specific individuals. And then you've got eyewitnesses and people telling their stories that can have a great impact on us based on the questions that these people are asked and their ability to tell the truth or lie in an effective way. So you've got all these things pushing and pulling at jury members, and they're asked in these cases to hear all this, to parse all this out, and then get together, and for those of you who don't know this, deliberate with each other and come up with a unanimous decision as to whether or not they believe somebody, at least in a criminal case, did something or didn't. And the insistence is that they're not unanimous. They have to return with saying that they're a hung jury and that this could potentially be retried again in the future. Now, very rarely do we see hung juries in court cases unless there's a perfect split amongst the group and nobody is willing to budge. But they exist, just not as often as we might think. Numerous studies have shown that many people, when they go to deliberate and talk with other members, have already come to a conclusion about the guilt or innocence of individuals. In fact, there was numerous studies that have actually asked people to report what their conclusions were about a court case before deliberating, then have these individuals deliberate and just test what the final outcomes were. And what the researchers found is that there is a wide distribution of beliefs that people have going into deliberation that leads to a very limited number of outcomes. In the cases, the 86 cases, where every single person over this time span that this study was done back in 2001 went into the deliberation room thinking somebody was guilty, 84 out of those 86 times, that group came back with a guilty verdict. Honestly, I don't know where those hung trials came from, but it's an overwhelming and obvious thing that we would expect to find. What's a little bit more surprising is in the cases where there were 11 individuals that suggested that somebody was guilty and one person that didn't find somebody guilty. Again, every time these individuals came back with a guilty verdict, minus 2 where they just came back with a hung jury conclusion. This was also true for a 10-2 breakdown and a 9-3 breakdown, even though it's important to note if you look at that fourth line that they often reported more hung jury cases than guilty cases. But in all of these situations, the minority, the people that didn't believe the person did it, were not able to sway the group and move them to their side. This is equally true when we look at those cases where the majority of people thought a person was not guilty, and there were up to four individuals that this person was guilty. In every single one of those situations, the group at best was willing to just leave with a hung jury conclusion. The only exception to this data, which I still cannot explain for the life of me, is that one situation where everybody going in and talking had the belief that somebody was guilty, not guilty, but came back with a guilty conclusion. I don't know how that happened. I have still not figured that out when digging through the data of this study. But, when you consider the things that we just mentioned, this really highlights how difficult it is for those in the minority, not minority groups, but those that disagree with the majority of the people on the jury, to sway the jury in their direction. There's even a movie made about this called 12 Angry Men, highlighting how people would react. I think we talked about this even. People would react to an individual that would not go with a group that had this unanimous belief minus this one individual. We even talked about the study that tried to replicate this and kind of the amazing things that they found within that study. What all of this highlights is that we, again, have a lot of complexity to these situations in court cases where juries are swayed by all these different elements and people can be pushed in different directions. And unfortunately, once people come to those conclusions, this deliberation process that we think allows people to bounce ideas off of each other doesn't seem to really achieve that very often. And the only cases where we see shifts and hung juries are the situations where there's really a wide mix of beliefs when people get together. If you have just one or two people in the minority, maybe three even, your chances of getting the group to bend are very, very low. Again, social psychology at work, even in these jury situations. So, where do we go from here? What do we conclude from this lecture that's been a little bit longer than some of our others? Well, what I want you to understand from this isn't that our legal system is messed up and broken and damaged. That's not the message that I'm really trying to convey here. What I'm trying to convey It's this recognition that even in something that we see as perfectly sterile, something that's supposed to be kind of this void situation where there is not all of the other aspects of our social psychology world playing into it, even in those situations, we see multiple instances of social psychology at play. And for us to pretend that these things aren't there is problematic. And fortunately for us, there have been movements within our legal system to adjust aspects of things like the interview process and jury deliberations and what judges can say and not say in court cases to try to sort of address some of these things that social psychologists have pointed out over the years. Odds are pretty good we'll continue to be adjusting these things over the next subsequent decades, trying to kind of get this legal system that many people do embrace and celebrate more closely aligned with the ideal that many people argue it should meet. And hopefully, with more and more research on this, more and more studies to look at the impact on members of minority groups or outgroups and how they're treated differently and how court cases might hinder on things that we don't necessarily think about that often. The more and more we study these things, the better and better we can get at trying to be as fair and impartial and, well, sterile as we hope this system is. And this is really important to kind of recognize that this is just one situation where we see this stuff happening. This is also true in healthcare. It's true in parenting. It's true in all of these different things that are a part of our everyday life. Right? Social psychology is everywhere. If you can recognize that, identify that, well, then this relatively long lecture sort of served its goal. And this is going to be, as I mentioned before, the finish line for us. We do have more readings that you can examine to look at other places where social psychology is at play in our everyday lives, but I think this is a really good place to wrap things up. This kind of closure and revisiting of past ideas so we can see how this is not just something that's operating in a bubble, but something that's everywhere in our lives. Hopefully you've gotten a lot from this. Hopefully I haven't said anything unintentionally that's upset anybody on this highly volatile topic. But, I think thinking about these things and discussing them is very valuable. So enjoy this, enjoy the readings. Hopefully you can study up for the next exam. And I'm sure I'll see many of you around. Until then, take care. Goodbye, everybody.